Hello friends, I welcome you all at Swayam platform. We are discussing a course Hindu personal law including marriage and succession. And friends, this lecture is the last lecture of this week. And the title of this lecture is Disqualification of heirs. But before starting the discussion on disqualification of heirs, I want to summarize what we discussed in the last class. In the last class, we discussed about the right to preemption, which means that preferential rights given to the co-heirs in a case of property which is immovable or the business. When a co-heir wants to sell the property which he inherited with another co-heir to a stranger, then co-heir have a preferential right, but co-heir must be the co-heir of the first class. They both by agreement may fix the consideration, and if they are not able to fix, they may approach the court and court may fix. The rule is simple. Suppose you proposes for purchase and now you court fix the consideration, but now you are now refusing from purchasing the property, then all the cost will be borne by you. This is the preemption which we discussed in the last class. Now friends, I want to focus on disqualification of heirs. Friends, why this disqualification of heirs is very fundamental in the law of inheritance, friends. Disqualification of heir means heirs who are not capable from inheriting the property. In certain circumstances, law not allowed a person to inherit the property, and we will discuss the circumstances under which a person is not entitled to inherit the property. Friends, before starting anything, I just want to highlight the learning objectives of this class. The first is disqualification of heirs from succession, meaning of murderer and his disqualification from succession. The third is converts descendant when disqualified and when not disqualified, disease, defect, etc. not to disqualify an heir. These are the category. On that basis, a person may be excluded from inheriting the property, and these are categorized in number of categories, and we will discuss one by one different kind of the disqualification. Friends, the idea of disqualification given in section 25, murderer disqualified, section 26, converts descendant disqualified, section 27, succession when heir disqualified, and section 21, 8, disease, defect, etc. not to disqualify any heirs. Friends, now I want to focus about the first provision, that is section 25, murderer disqualified from inheriting the property. Friends, in America, very interesting case came, Rich versus Palmer. A grandson murdered the grandfather and accepted that he murdered grandfather, but he claimed that because he is heir, the property should be associated with the grandson. But court finally concluded that a person must be clean hand, the property will not given to the grandson. Friends, this is a very established rule. Who murdered a person through whom he want to inherit the property, in this case, murderer have no right to inherit the property. What is the rule of section 25? A person who commits murder or abates the commission of murder shall be disqualified from inheriting the property of the person murdered, or any other property in furtherance of succession to which he or she committed or abated the commission of murder. Murderers disqualified. Friends, now I want to clarify the rule of section 25. This section states that a person who has committed or abated murder shall not be eligible for inheriting the property of the murdered person or any other person in succession of the murdered person. Friends, two different kind of property are disqualified to inherit. Friends, the two kinds of persons are disqualified to inherit the property. First is the person who commits murder, and second, the person who abates the commission of murder. Both category of persons are disqualified from inheriting the property, and property also categorized in two categories. The first one is the property of the person who is murdered, or any other property in furtherance of succession to which he or she committed or abated the commission of murder. The property of deceased one, or he want to break the line and he want to become direct successor of the murderer, therefore he committed murder of a son and daughter. Then he also not eligible to inherit those property in furtherance of which he committed the murder. Friends, in a case of M. Nagarajan versus V. M. Nagmalla, it was held that murderer should be treated as non-existence for the purpose of succession. Friends, now fundamental question is, what do you mean by murder and murderer? How the definition of murderer can be ascertained by the court? Friends, in the case of Minoti versus Sushil Mohan Singh, AIR 1982 Bombay High Court, the court held that the two acts, Hindu Succession Act 1956 and Indian Penal Code 8060, are not in pari materia. Therefore, the word murder used in section 25 of Hindu Succession Act cannot be construed in the light of its definition under section 300 of IPC. Now it is defined under section 101 of the BNS 2023. The word murder here means unlawful homicide or unlawful killing. Murderer has to be construed in the view of the object of legislature in making the provision. So you may derive and define the murderer and murder both in the light of definition, not in the light of IPC, Indian Penal Code or Bharatiya Nagarik Suraksha Sanhita. Friends, the object here is to refuse the benefit to a person from him own crime, that is to prevent him getting the benefit from his own wrong. Therefore, no technical meaning is needed in this context. We will construe murderer as it is understand in general parlance or in a popular sense. How we can understand the meaning of murder? The meaning of murder cannot be construed in the light of criminal law. We should analyze and explain the term murder and murderer both in the parlance of the Hindu Succession Act. Means if a person unlawfully involved in killing or unlawfully committed homicide shall not inherit the property. Criminal law prefer strict interpretation, but under this section strict interpretations is not a rule, and therefore the liberal interpretation of murder term is also possible. Friends, Now I want to focus on the relevance of motive, as there is a relevance of motive under the Hindu Succession Act, friends. Generally, motives are irrelevant under the criminal law, but this is relevant for the purpose of Succession Act. A person is not disqualified mere charge or suspicion of murder. The civil court is bound by the decision of the criminal court. Suppose if criminal court finally concluded that Mr. X committed murder the Y, then civil court is bound and the property will not inherited by the murderer, because it is proved, and therefore civil court will not provide any share to the property. Friends, the participation in murder is sufficient. You may be a person may be actual murderer, or a person who abetting or somehow participating in murder, friends. Friends, now another case is commission of the suicide due to the behavior of the heirs. In this case, TPK Visalakshmi versus TV Visalakshmi, Andhra Pradesh High Court observed that suicide by the husband is killing himself. It is not murder by the wife within the statutory meanings, scope and ambit of the word murder. Therefore, in a case of suicide, and if it is not proved otherwise, in general parlance, that no one can disqualify from inheriting the property. This shown that there is something desirable in the language of these provisions. If a person directly involved due to the behavior of a person adopted suicide, committed suicide, then obviously he should be or she should be not eligible for inheriting the property. Friends, this is the point which is very crucial and important. Friends, now I want to focus on another ground of disqualification, that is section 26, converts descendant disqualified, where before or after the commencement of the act, a Hindu has ceased to be Hindu by conversion to another religion. Children born to him or her after such conversion and their descendant shall be disqualified from inheriting the property of any of their Hindu relatives unless such children or descendant are Hindus at the time when the succession is open. Friends, section 26 is very simple rule. Convertee descendant are disqualified. Under section 26, a convertee is not disqualified, because everyone have right to religion and right to profess. Therefore, due to conversion, you cannot be disqualified from inheritance under Hindu law. But convertee descendant who are not Hindu at the time of succession opens cannot inherit the property from deceased Hindu. But when they are Hindu at the time of succession opens, they also can inherit the property. Friends, under the old Shastric Hindu law, the man who converted from Hinduism was, this is a ground of the disqualification. Friends, but this rule was amended during the British rule. The provision was not amended during the Muslim rules, a large scale conversion of Hindus to Islam. But during to the English regime, the provision of the personal law was abolished. Section 9 of the Regulation 7 of the Bengal Code 1832 helped the Britishers in propagating their religion. They developed a law which is known as Caste Disability Removal Act 1950, protects the convertees to inherit from inheritance. Friends, now the Britishers let down the clear rule that after the conversion, you cannot lose your right. This is the fundamental gist of Caste Disability Removal Act. And originally Caste Disability Removal Act provided that if a Hindu converted in Christianity cannot lose the property right of inheritance. But now it is a neutral provision. Now I am explaining the section 26, person who are disqualified from inheritance. Two kind of persons are disqualified from inheritance. First, the children born to the convert after conversion, i.e., for example, non-Hindu children of such convertee. The descendant of these children, the non-Hindu descendant of these children also not eligible from inheriting the property. The condition of their disqualification is that they must not be in existence at the time when the succession opens. The person not disqualified due to section 26, the convertee himself, the Hindu children of the convert born before the conversion, children of convert who is Hindu at the time when the succession opened. Friends, section 26 and its scope is very limited. Convertee is not disqualified, and the children of the convertee born before the conversion is also not disqualified, and a children who is Hindu at the time of succession opens also not qualified. So, although this is a provision on paper, but when you are going to apply the disqualification on the basis of section 26, the scope is very limited in India. And this is another example of the liberty of Hinduism and our practices. Friends, other relevant point in the reference to section 26, the conversion does not include the change over any faith inside in the fold of Hindu Dharma or religion. Friends, suppose a Hindu converted in Buddhism, Jainism, Sikhism, they cannot considered disqualify, their heirs cannot be considered disqualify under section 26. Conversion outside the Hinduism is relevant for the purpose of section 26. If the children of convertees are Hindu, although their ancestor is not a Hindu, they would be entitled to succession. Section 26 is a retrospective provision, that is, it is immaterial whether the conversion took place before or after the commencement of Hindu Succession Act. In both the contexts, it is applied, friends. So friends, now I concluded my discussion on section 26, which try to explain that convertee descendants are disqualified from inheriting property. Therefore, a convertee itself not disqualified. Children of the convertee born before the conversion is not disqualified. Children born after the conversion but at the time of succession open, they are Hindu, they are not disqualified. Therefore, scope is very limited. But fundamental rule should be very clear that if a person converted within Hinduism, faith of Hinduism, from Hindu to Buddha, from Hindu to Sikh, they cannot be considered disqualified. Friends, now I want to focus on section 27, succession when the heirs disqualified. If any person is disqualified from inheriting any property under this act, it shall devolve as if such person had died before the intestate. Friends, section 27 is very simple and clear. In a case of disqualification, the section 27 concluded that who disqualify, law will be treated them non-existence and property will devolve while ignoring them. Although they exist, but law will treat that they are non-existence. Friends, section 27 creates a legal fiction. It will be deemed that disqualified heir had died before the intestate did, and the succession will pass over him. This section states that if any person is disqualified from inheriting any property under this act, it shall be devolved as if such a person had died before the intestate. Means section 27 presumed a legal fiction is created. Law will presume that disqualified person already dead before the death of intestate, and therefore succession will pass over the person and he cannot receive anything from the property of deceased person if he is disqualified. Friends, now I want to discuss a case, succession when the heir disqualified. This is an interesting case, Veli Kannu versus R. Singa Perumal, 2005, 6 SCC, page number 622. Brief fact of this case: a person murdered his father and was convicted for murder under section 302 of Indian Penal Code and was sentenced to life imprisonment, but was released after serving few years. After his release, he claimed his share of his father's property. As per section 25 of the Act, person who murdered a deceased person is disqualified from inheriting the deceased person's property. Now, fundamental issue involved. The issue arose in the case was whether the wife of a person who has murdered his father can inherit the property of her deceased father-in-law. Friends, rule is very simple and clear. Murderer disqualified as per section 25, therefore murderer cannot claim the property from father. But now the question is, murderer wife is eligible to inherit the property from father-in-law. Means a person who claiming because of murderer or on the basis of murderer can inherit the property in a case of murder or in a case where the heirs is disqualified from inheriting the property. Friends, the observation of court is very critical and clear that here in the case the murderer died after some time. Now, as per the law of succession, the widow is entitled to claim through son, but here the son is already disqualified. The Supreme Court held that murderer is disqualified from inheriting the property of the victim. His disqualification extends to the murderer's right to succeed the property of victim by survivalship. The Supreme Court held that wife of the murderer son is also disentitled to succeed the property of her father-in-law murdered by her husband. Appellant widow had forfeited her right to inherit her father-in-law's property by virtue of her husband's conviction for murder. What is section 27? When murderer disqualified, then section 27 will presume that a disqualified person not exist, and then disqualified person may be passed by the court. Friends, now we have a two contradictory provision. Under section 26, it is very clear that convertee who is guilt, convertee is not disqualified from inheritance of the property. Their heirs are disqualified from inheriting the property. Under section 25, murderer is disqualified, and for other purposes the provision of section 25 is silent. But this case is very clear, where Supreme Court concluded that wife can claim the right in the property of father-in-law on the basis of son. Son is already disqualified due to the conviction and due to the murder. Therefore, wife cannot claim the property on the basis of murderer. The murderer is disqualified as well as a person who claiming any rights on the basis of murderer also not entitled to inherit the property due to the disqualification of heirs, friends. Now section 28, disease, defect, etc. not a ground of disqualification. No person shall be disqualified from succeeding any property on the ground of any disease, defect or deformity, or serve as provided or save as provided in this act or any other ground whatsoever. Friends, now the rule is very simple and clear. On the basis of disease, defect and deformity, a person cannot be restricted from inheriting the property. Under the Shastric Hindu law, physical defect, mental defect, moral and religious defects are recognized and they considered as not disqualified heir from inheriting the property. But friends, now under this legislation, disease and defect is not a ground of disqualification of heirs. Friends, now we have a Caste Disability Removal Act. Conversion and change of caste was no more ground of disqualification. Hindu Inheritance Removal of Disability Act 1928 abolished disqualification on the ground of diseased or physical deformity or mental health. Now it is abolished and the provisions reflected in section 28. Friends, now on that basis we can conclude that no disqualification for disease, defect or deformity. Ground of disqualification is exhaustive under Hindu Succession Act 1956. No any other ground which is not provided in this act can be a ground for disqualification. No ground for unchastity or any other such ground is recognized for disqualification of a heir. Friends, provisions are prospective provisions. In a case of Appa Sahib versus Guru Basavanna, the Supreme Court held that section 28 is prospective provisions. It governs the cases where the inheritance open after the force of the Hindu Succession Act. If there was a disqualification before the act, the rule is different. But disqualification must be exist after the commencement of this act. Only in that context the person may be disqualified from inheriting the property. Friends, by this discussion I want to conclude the idea of disqualification of heirs under the Hindu law. Section 25 talks about the murderer. Murderer is disqualified from inheriting the property. Be careful about the Rich versus Palmer in America, where the grandson finally declared disqualified from inheriting the property of grandfather because he murdered the grandfather. But now section 25 is clear. A person is not entitled to inherit the property of murderer or any other property in furtherance of that murder is committed by the person. Who is disqualified? Actual murderer is disqualified or abettors are also disqualified. And due to the progressive interpretation of Supreme Court, any person who is claiming rights on the basis of murderers also disqualify from inheriting the property. Therefore, wife cannot claim inheritance from the property of father-in-law if husband committed murder of the father. This is section 25. 26 is convertee descendants are disqualified. Convertee descendants are disqualified, but scope of section 26 is very limited. The convertee is not disqualified. Convertee descendant who born before the conversion also not disqualified. Born after the conversion but at the time of succession open, they are Hindu, they are also not disqualified. Now the question is, who is disqualified? a descendant born after the conversion and at the time of succession open is still he is not Hindu, then he cannot inherit the property under section 26. But any kind of change in faith within Hinduism, Sikhism, Buddhism, Jainism not disqualify a person from inheriting the property. We accepted the constitution where right to religion, practice, profess become fundamental right. Therefore, such restrictions are very limited in our context, friends. Now, friends, section 27. Section 27 is about that where disease, defect and deformity is not a ground of disqualification. Suppose a person suffering with disease, mental illness, because of the existence of disease and suffering, he or she cannot be disqualified from the inheriting the property. This is the principle based on general rule under the Shastric Hindu law, where I discuss with you that physical defect, mental defect, moral defects recognized, but now due to the illness and defect, no one can be prohibited from inheriting the property. And another fundamental rule is, friends, when a person is disqualified, how the property will devolve? The property will devolve with the help of legal fiction. And what is the legal fiction? A disqualified person is not in existence. And when the law presume, although he exists in existence, but fiction created by the law is he will treated as non-existence. The law bypass the person and not allot share to that person and allot only the person who qualify for inheriting the property. These are the provisions. On that basis we are able to understand the law of inheritance and disqualification of heirs. Friends, by this discussion I concluded my lecture of the 7th week, and we also concluded the discussion on Hindu Succession Act. Friends, under Hindu Succession Act we discussed detail about the copasnary, copasners, joint Hindu family. We also discussed the dissolution of interest as per section 6, where we also discussed this 2005 Amendment Act. On and from the commencement of this act, daughter become entitled as a copasner, have a same right, same status, have a same liability. Doctrine of pious obligation is now abolished. Rule of survivalship is also abolished. Friends, we also discussed the interesting case, Vinita Sharma case, and another case, Phulvati case, where the conflicting interpretation of Supreme Court is there, but finally Supreme Court concluded that copasnary is by birth and therefore daughter is copasner by birth. There is no need to prove that living daughter of living copasner at the time of on and from the commencement of the act. We also discussed the Hindu male dying intestate, section 8, firstly first class heir, secondly second class heir, agnates and cognates. And we discussed the detailed rule of section 9, 10, 11, 12, 13, where we discussed that widow will take one share. In a case of more than one widow, they will take together one share. Son, daughter and mother will get one share. And branch of predeceased son and daughter will get one share. 10 rule 4 talks about the how the property can be distributed if the branches inherited the property. We also discussed the second class heir. For the purpose of second class heir, we discussed that they are categorized in 9 category, and section 9 part 2 concluded that preferential share within the entry they take simultaneously, but so long as first entry exists, second entry cannot inherit the property. And we discussed the detailed rule about the second class heirs. And in the absence of first and second class heir, we also discussed the idea of agnates and cognates. Who is agnate? Agnate means two persons are agnates wholly connected through the male, means grandson and grandfather agnate. because wholly connected through the male. But mother's father and son is connected through mother, therefore they are agnate. We discussed the rule of section 13, how we can calculate the degree between them, and section 12 is a fundamental rule. We also discussed that. We also discussed in this week about section 40, property of Hindu female, which includes Istridhan and so on. We discussed the detailed idea of Istridhan, and then we also discussed the idea. We also discuss about the section 15 and 16 in this week, where we discuss the Hindu female dying intestate and what are the rules of succession in a case of Hindu female dying intestate. And then we also discuss today, we also discuss about the general provisions related with succession, where we discuss the child in womb, where we discuss the common per stirpes per capita. Preferential right is also discussed in this week. And today we concluded the discussion with the disqualification of heirs under the Hindu Succession Act. Friends, in this background, you may think on certain point. Would it be correct to say that Shastric Hindu law did not provide for such valid ground for disqualification? Whether a disqualified heir is to be treated non-existent, or should he be treated as predeceased? A convertee does not lose his or her right to the property, but his descendant does lose. Is it rational? On this background, friends, I hope that you already well versed about the Hindu Succession Act 1956 and different provisions related with 1956 Act of Hindu Succession. Thank you, friends. Thank you.